welcome to Do Not Pass Go, What to Do When an Employee Gets Arrested. I'm Mike Coffey, President of Imperative Information Group. We're an employment background screening company in Fort Worth, Texas, serving clients all over the U.S. and now Canada. And we've got clients with operations internationally as well. But my background is as an HR guy. I stumbled into this industry really almost 19 years ago, and started in my HR consulting practice, kind of morphed into a background screening company 16 years ago. So what, a lot of what I do is spend most of my time still consulting with clients, primarily around their selection process, certainly background screening, increasingly on the requirements around background screening and use of criminal history on a state-by-state basis for multi-state employers, or even municipality by municipality in some cases. So that's just kind of one of the realities of being an employer today, is that you do have a lot of requirements that are placed on you by even local city councils or county commissioners, things like that. And so we spend a lot of time, I spend a lot of time working with clients around their selection problems there. So today we're going to talk about something that happens quite a bit. You've got an employee, and he or she gets arrested, and then you're trying to figure out what to do. And hopefully, if you've thought through it, you've got a process in place, a policy in place, so that you just don't leave it to your frontline managers to figure out what's appropriate. This presentation is actually one we first did a couple years ago. I did it with Julie Ross, who's an employment law attorney that some of you know, and who I present at an employment law conference every April here in Fort Worth. She and I are usually the luncheon speakers at that, and she provides all the information, and I'm the wisecracks and levity for the presentation. But so a lot of this is stuff she and I put together, so I want to make sure I give her good credit because she's smarter than I am. So we'll start by talking about some of the terminology that you really need to know when we're talking about criminal records in general, because not just on the when you're dealing with an employee who's arrested, but just in general talking to applicants about their criminal history. Often they get the terminology wrong, and they don't understand what their attorneys are telling them. And so often we hear things like, well, my lawyer said that wasn't going to be on my record. Well, that's not really the case. It is on your record, but it's showing that you got probation and the case was dismissed after completing probation. So it's not a conviction, it's a deferred adjudication or something, but it is on your record. And so it's important as we talk through some of this stuff to first make sure we're all on the same page as far as terminology. So citations, basically, these are minor offenses, traffic offenses, public intoxication sometimes, things like that, for which you can get a ticket, and often at the officer's discretion they can arrest you and take you into custody, but typically they're things that aren't punishable typically with a jail sentence unless you do something to aggravate the situation. But you still have to make an appearance in court or at least show up to pay a fine. Now when we're talking about an arrest or a detention or being booked, that means you've been taken into police custody. Detention, may not amount to an arrest. You're not going to be taken into custody and taken to the jail that night, let's say. But it could mean that you've been set aside from by the police from another person. They've set you, maybe in the back of a squad car, or set you down on the curb, something like that, to run your information and make sure everything's okay. And it may be a precursor to an arrest. It could mean that down the road a case may be filed against you. And booking is when, after you're arrested, you're actually brought to the jail and they record your identity information, take your photo, do those things, and then either put you in jail or they do a walkthrough where they release you immediately, but they booked you into jail. And So that's what those terms typically mean, and we'll talk about them in a little bit. Also, let me suggest that throughout this presentation, just if you have a question that comes to mind, go ahead and type it into the question box and send it to me. I will answer them all at the end, but feel free to send them on as you think of them so you don't have to keep up with them. And then we'll spend as much time as we need to at the end answering all of your questions. So a warrant for arrest means that there's actually a judicial order out there, something signed by a judge saying, bring this person into custody or bring them before the court. And we see these in criminal cases, but we also see them in civil cases. In a civil case, say, for instance, a family law case, a judge can find someone in contempt of court and for not following a court's order on something and issue an arrest warrant for them as well. Now, criminal case filing is the initiation of a criminal case by the local prosecutor, whether that's the district attorney or whoever it is, state's attorney, whatever it's called in your state. That arm of the executive branch has come forward and said, we think there's reasonable cause to accuse this person of this crime and to prosecute them. That also means in most jurisdictions that if a criminal case is filed, that either if it's a felony, it's been presented, it has been or will be presented to a grand jury, and the grand jury will review the information presented by law enforcement and the DA's office or the prosecutor's office, and determine if there's probable cause or if it's reasonable to proceed. That's not a finding of fault or conviction, and as one judge said, most grand juries will indict a ham sandwich if asked to do so by the prosecution. So certainly I wouldn't want you to say just because he was indicted means he necessarily is guilty or did it. But that's a step closer to it being reasonable for you to believe they engaged in that conduct. In misdemeanor cases, it's usually just a paper filing, and often those go before some sort of lower level judge, a magistrate judge, an administrative judge of some sort, who looks at the filing and makes sure that paperwork's in order and that the case that's being brought has enough cause, probable cause, or reasonable cause to bring the case forward. Pretrial interventions or diversions, these are programs where basically the prosecutor can come forward and say, rather than prosecute this case, we will let you agree to go to some sort of probation. And that may be anger management classes, it may involve some sort of drug rehab or drug education classes, things like that. But if you complete these, and sometimes it's just stay out of trouble for 6 months, if you don't get arrested and have any problems in the next 6 months, then we will not prosecute the case and we'll dismiss it. So that's very similar to a deferred adjudication case, but the deferred adjudication is typically more under the judge's supervision, and whereas in a lot of jurisdictions, pretrial diversions are offered by the prosecution, but in both of those cases, in both pretrial intervention and a deferred adjudication, you do have to admit either enter a plea of no contest, which means I'm not going to disagree and argue about the charges against me, or a plea of guilt. And so in either of those cases, if you fail to perform whatever the requirements for the job were, or for the requirements of the probation were, the case will be dismissed. Or if you fail to do it, you can have that conviction, or that, I cannot talk today. If you fail to complete the terms of the probation, then the admission of guilt or no contest can be entered against you and you can be convicted. So that's why we, in most jurisdictions, many jurisdictions, when we're talking to a client about how do we consider this deferred adjudication or this pretrial diversion program, we'll tell them, well, let's pull documents and let's see if there was an admission entered and what the terms were. And probably if they've admitted it or pled no contest to the offense, it's reasonable for you as an employer to believe they engaged in that conduct, and so you can make a hiring decision. At the same time, you do want to get that additional information, and you need to remember that there are some states that don't allow an employer to consider a case where that's been dismissed, even if it was something where they entered a plea of guilty or no contest. The employer can't consider that once the case for you to recognize. Then a deferred adjudication, like we mentioned, that's typically something issued by a judge. The case, and then the person serves some sort of probation after entering a plea of guilty or no contest. And again, if they failed to meet the requirements of that probation, they can be found guilty. The conviction can be entered, and then they can be sentenced by the court. So again, if in most states it is legal for an employer to consider a deferred adjudication or a dismissed case. Now, I'm not telling you to necessarily do that. You want to talk to your own legal counsel, and if they disagree with me, have them call me. We can talk about it. The real key is if the person engaged in that conduct, and you've determined that that conduct is unacceptable for this position, then that's really your outcome. A dismissal means that the case is terminated. It's over, and right now it's not being prosecuted anymore, but it may. You see, dismissals with prejudice which means it's dismissed, and this set of facts cannot be brought to the court again against this plaintiff or this defendant. And then there's dismissed without prejudice, which means that the DA can go back and do further investigation, and if they choose, they can prosecute the case again and bring it up for a second bite at the apple. In those cases, it's if somebody's found a case is dismissed outright by the DA or by the court for some reason, you'll usually get a determination as to the reason why. And it's always important to know why the case was dismissed, because again, just because it was dismissed does not mean the person didn't engage in that underlying conduct. It may have been dismissed because they pled guilty in another case. It could have been dismissed because the complaining witness didn't want to participate in the prosecution. But that doesn't mean the person didn't engage in the conduct, and so you need to do additional research to figure out why it was dismissed and what you're going to, whether it's reasonable for you to consider this dismissal as part of, in the employment context, the applicant's background, but in the case of a current employee, whether they're fit for continued employment. And then an acquittal or not guilty, that's where the person is actually, the jury has said that the prosecution did not prove their case, and those cannot be refiled. So once now again, an acquittal or not guilty doesn't mean the person didn't engage in the conduct. All it means is that the prosecution couldn't prove beyond a reasonable doubt that the person engaged in the illegal conduct. So again, we'll talk about this more, but an employer doesn't necessarily have the same standard as a prosecutor and as a court. And so it may be reasonable for you to believe the person engaged in that conduct, but the not guilty or the acquittal came for some reason other than the person's actual innocence. And we'll talk a little bit more about that. And then, of course, a conviction is where you've been found guilty by the court. So a deferred adjudication is not a conviction, but a conviction is where the person's actually been charged and the court has found them responsible, either after a jury trial or their plea of guilt or a bench trial by the judge. So talk about your legal considerations when different kinds of things that may come up when you're talking about the employees' off-duty activities. First of all, what about off-duty conduct? You'll hear from some employees who say, hey, it's none of the employer's business what I do when I'm not at work. Well, that's sort of right. There are a handful of states that protect off-duty conduct. Actually, the majority of states have some law protecting some kind of lawful off-duty conduct. For instance, there may be 10 or a dozen states that have protections for the use of tobacco. We've actually got employers who have self-funded health insurance programs, and one of their rules is for that employer that you cannot test positive for nicotine, and they do nicotine tests just like they do drug testing. And in Texas, that's legal. In other states, that's not legal. So that's a kind of off-duty conduct that's protected by some state statute. There are also protections for social media conduct in some states. Let's see, California, Colorado, New York, and North Dakota have protections for all lawful activities. So an employee can do anything legal outside of work, and in those 4 states, California, Colorado, New York, and North Dakota, they can not have action taken against them by the employer. But even these laws aren't absolute. For instance, in Colorado, marijuana is legal, but the Supreme Court in Colorado just recently came out and said no, in fact, it may be legal in California, but it's illegal under federal law, and an employer can take action based on somebody's use of marijuana if they test positive for drugs, even if it was off-duty. So, off-duty conduct when it's illegal is really open for employers to consider as long as it's relevant to the job. Just like subject to basically the same kind of considerations you'd have when you're looking at your criminal records in the employment context. Then there's the Civil Rights Act of 1964, Title VII. Because minorities are arrested, prosecuted, and convicted at a higher rate than the white population, you run a risk when you use any kind of criminal history in making an employment decision, whether it's a hiring decision or a retention decision, of creating a disparate impact. And by doing that, you may, when there's a disparate impact, create illegal discrimination. But may does not mean you will. And so if you've got a business necessity for your consideration of that criminal activity, in other words, you say, well, this person drives a motor vehicle for us, and so that DWI would eliminate them from this position, then that's a business justification. So even if somebody, if a particular protected class had a really high level of people who were excluded from employment based on that criminal history, that kind of conduct, it would be perfectly legal to say as an employer, we're not going to hire people with recent DWIs for certain jobs. We have whole webinars, we got 2 of them recorded on our website concerning Title VII and how employers should consider criminal history and its relevance to the position. And so I would recommend, if you've got any questions on that, certainly feel free to ask me, but we've got some webinars recorded on the website that'll probably be helpful as well. Another consideration is libel, slander, defamation of character. The real issues there are just, again, you don't have all the facts. If an employee is getting arrested and somehow you found out about it, you don't have all the facts, and so really you need to really limit the scope of the people who you involve in any kind of discussion or investigation so that you don't have a large group of people out there talking about this person's arrest, because it can turn ugly real quick, especially even if you're doing everything right. You've got some knucklehead employees out there, and if they get wind of something, they're going to be telling other employees, and there's going to be somebody who's got an axe to grind with this particular employee, and he may exaggerate or make the actions or the things that have happened sound worse for that employee, and suddenly you may be looking at some sort of libel or slander claim or a defamation of character claim. So it's really important that your policies give some assurance to you and HR that you're really going to keep this stuff quiet. We're going to manage it internally and involving as few people as possible, just really on a need-to-know basis. Another big issue, and this is one that's come up with a few clients over the years, is cooperation with law enforcement. You've got an employee, and maybe the employee doesn't even know there's something coming, and a detective shows up and comes to HR and says, I'd like to see this employee's file. Well, before you do that, talk to your legal counsel, and you need to have your policy that outlines, here's what we do when we're asked for employee information from law enforcement. And your responsibilities may change for a variety of reasons, collective bargaining agreements you may have, state or local law. So you need to make sure that you talk to your legal counsel when law enforcement shows up. The other thing to remember is there's no privilege out there for an employer. So what an employee tells you isn't protected like the attorney-client privilege. So if an employee admits to you that, yes, you know, I had 5 drinks that night at the bar after work, and then I drove home and the police popped me, if you get summoned as the employer to say what the employee told you, you know, you may have to show up and say that. His attorney is certainly going to try to avoid, you know, prevent that. But you just need to know whatever they tell you, it doesn't have any privilege. Now, it may or may not be admissible in court depending on the circumstances, but just know that anything you create during the investigation may be something that the district attorneys, prosecutors, or even a detective can get a subpoena for. So it's important to remember that. So how do you find out about these things? You know, it may be that kind of deal where somebody knocks on the door in HR and says, hey, you know, I don't want you to do anything about this, but I heard that Paul got arrested this weekend he got in a fight with his wife, and the police came out and arrested him. Well, they don't want you to do anything about it, but I would suggest that you probably have, for certain positions at least, a responsibility to follow up and do an investigation, especially if this person's in a position where they work with vulnerable populations or children, things like that, or where somebody with some sort of violence going on in their lives would be a red flag. And I'd say, really, when it's a current employee and you hear about some sort of violence, you've got some real concerns about workplace safety and workplace violence and prevention. So, you know, you probably want to find out at least the details. It doesn't mean you're going to take action on it or not, but at the very least, you probably need to verify the information. The employee, you may have a policy that says if you're arrested or detained by the police, you've got to contact your supervisor or HR within 24, 48 hours, something like that. So that may be how you find that information out. Sometimes the employee just doesn't show up, and it's an employee no call, no show issue, or their spouse calls and says, John's not going to be at work today. And you say, okay, well, I need to speak to John. You don't work for me. And they say, well, John's not immediately available. And ultimately, maybe you'll find out that, from John's spouse or somebody who he had called. We had a client who got a call from another inmate who, on his way out of the jail, our guy said, hey, call my boss and tell him I can't come to work today. And so this inmate, who was a perfect stranger, this guy calls up the employer and says, hey, I was talking to this guy in jail, and he wanted me to call you and tell you he couldn't come in. As an applicant, as an employee, that's probably not your best way to handle that. But and sometimes they just don't show up, and you start doing some investigation, and you find out, well, they're in jail. And I know we've got one client who, when they don't have somebody show up, they just assume he's in jail, and they'll call us and say, hey, can you track down our guy and see if he's around? And we'll go look, and there he is in the local jail. Periodic background checks. If you do annual background checks on your employees, you may find something out that, oh, well, look at this. He's got, a DWI, which we see a lot of in the last, since we checked him last time, he's had a DWI filed against him. Or you find something else, domestic violence or some sort of theft or something. So that's another way you'll find those things out. Worst case scenario, it shows up on the 10 o'clock news. You're sitting there watching the news at night, and bam, here's one of your employees wearing your uniform, doing the perp walk between the cameras with law enforcement on either side of them. So that happens on occasion, or it may be in the newspaper. There's some sort of we've had that with clients too, where they find out about an employee when the newspaper comes out, and they've been arrested for something. And then internet and social media, it's all out there, and you may see even your company Facebook page may blow up with people posting stuff about somebody who works for you who got arrested. These are probably, usually when it's pretty heinous or high profile. So you need a notification policy. This is really where we start really talking about policy things you need to have in place. And it really basically needs to say, this covers any arrests or other detention by law enforcement. So even if they're just detained and they're not arrested, there may be a police report filed, and you want your employee to tell you about it. It may not lead to any other prosecution, but at the very least, let's find out what was going on. And it's better to know now than wait 3 months. If this activity is something that would call into question this employee's fitness for this job, we need to know what it was. And quite honestly, you can't take the employee's word for it. So if they tell you that they were arrested or detained, but they tell you don't worry about it, it's not really relevant to what we do here, don't take their word for it, because quite honestly, we'd be out of work if all your applicants and employees were honest, and they tell you some pretty weird stories sometimes when you look at the reality. They should also tell you whenever they're contacted by law enforcement about their own conduct with regard to a criminal investigation. So even if they haven't been arrested, if law enforcement, come to them and ask them, questions about their own activities or involvement in some illegal activity, your policy ought to say, you've got to come to us and talk to us about that. If they have any temporary or permanent restraining orders issued against them, again, you need to look at them and figure out if they're relevant or not. I mean, unfortunately, these are really common in divorce cases, and you want to be really cautious in how you deal with those things. But if there are allegations of actual violence in one of those or other illegal activity, from a workplace safety point of view, you need to know about it. And so it should be the employee's responsibility to tell you about it if it happens, if one's issued. And if they have any finding of contempt by any court. And private employers are probably less concerned about these, but some of our public employers are really interested in them, especially when it's a public safety position. So if they've got a police officer who's been found in contempt of court during a divorce proceeding, how might that affect that police officer's ability to credibly testify against a defendant or testify about their activities in a criminal case if the other side finds out that they've been actually found in contempt of court in another matter. So at the very least, again, you should know about it. And then certainly if there's a criminal case filed, with the exception of minor traffic offenses, which aren't typically considered criminal offenses, and they weren't taken in custody. So these are the things that you really want to make sure your policy tells your applicant or your employees, we want you to notify us. And then when do they make the notification? Really, I'd say immediately during normal business hours or at the beginning of the next business day. So if it's a Friday night and your offices are all closed on the weekend, at the beginning of the next business day, they need to contact you Monday morning and say, hey, this has happened. That needs to be the first thing they do that day. Policy should also reiterate your no-call, no-show policy, because just because they were arrested doesn't give them any protections. And if your no-call, no-show policy says that, you know, if you don't show up for work, you're terminated, and they don't show up for work because they're in jail, follow your policy, and unless there's a reason to deviate from it, and always when there is, you want to go ahead and document it. You want to make sure you have documentation about why you didn't follow your policy in a particular situation. Whatever the employee tells you, have them write it down. That's really key, because the story may change 3 times over, you know, over a period of days or weeks, or even in one telling in one meeting. So we always say, have the employee write down what happened, all the circumstances and what led to the arrest. Now, like I said earlier, as an employer, you don't have any kind of immunity or any kind of privilege. So what the employee tells you can be used against that employee in some cases. However, I would argue that your job is not to act as the employee's attorney or to try to protect the employee. Your job is to make sure the employee is safe to return to work, and it's appropriate for that person to return to the workplace. And so one of the conditions is you got to tell us what's going on. And if they refuse to, and what will happen is their lawyers will say, you know what, we've told him not to tell you anything, and their lawyers probably will tell them not to discuss it with anybody. And the lawyer may even contact you, but your answer is, if he's going to stay employed here, he's going to tell us what happened. Otherwise, because we're not going to, you know, just take that flyer that we can trust this employee, and that, you know, when he says nothing happened, or this isn't something that I didn't do it, but you know, clearly it led to an arrest. We want to know the circumstances. They refused to do that, then they're violating your company policy, and it'd be perfectly reasonable for you to terminate them after talking to your employment law attorney. But I would suggest that, at the very least, if they refuse to give you information, you're suspending them without pay until the matter is resolved, or they can give you some explanation. Sometimes you'll get information from other employees. Document that too, because either if those employees were involved in it, or they witnessed something, or you know, maybe it's something that happened in the workplace they know about, or they, you know, this employee told them that, you know, they got arrested this weekend or whatever, or you know, on a side issue, told them, made any admission of illegal conduct that would be of concern in the workplace, and another employee brings it to you. Make them write that down. Have them write down everything as accurate and clearly, and help them do it. Ask really specific questions. Make sure that you've got it recorded. And even if you're recorded, I mean in paper, but even if you are going to write it down yourself and have the employee just tell you, have them sign the bottom of the document, so that you've got documentation that they've agreed that that's what they told you. If you have any conversations along the way with law enforcement, detectives, private investigators who may be even working on behalf of your employee or their attorneys, go ahead and document that. Make sure you record write down everything that happened along the way, and keep everything with a time and date stamp on it, so that you can, if you're ever called later on to testify in this case, or maybe in a case brought against you by the employee, or even a negligent hiring or retention case, you've got documentation of every conversation you had and every action you took, and it's just, you know, employee investigations 101 stuff. And again, remember that you don't have privilege, but you can, when the law enforcement comes knocking at the door asking for a copy of the employee's file or any information you have, you can always require a subpoena or court order for the information, and that's what I recommend you do. Go ahead and ask them for that. And let me see, I'm just looking to make sure. Okay, good. Let's make sure there were no questions that I needed to address immediately. Okay, other considerations would include what's your confidentiality policy? You know, your policy may say we never discuss any of these things, and it's fine, but what if it's an officer of your company and it's all over the media, and maybe you even got news cameras staked out outside of your workplace? Is your policy just going to be, we're not going to say a word to anybody about anything? That could be more damaging to you as a company than at least making a statement that's you know, maybe even very milquetoast, but at the very least you're making a comment that may be helpful to putting your company's message out there. And you may even need a media plan. If something is really hairy, I worked for an employer a few years ago that we had a large internal theft, and it was a very prominent employer, and it became a news item on a slow news day, I guess, about all this theft, and it involved a director in the company. And so, because of the amount of attention they were getting, it was necessary to pull in. We brought in an outside media consultant to, you know, help write their appropriate responses and to try to manage the company's image through all of this, while not necessarily throwing our own employee under the bus. He kind of threw himself under the bus in that situation. So what are your responses when this stuff happens? When somebody's not available for work, you can certainly follow your no-call, no-show policy. I would really recommend that you stick to that like you would any other employment situation. You can allow the employee to allow them to return to work. You know, it needs to have that caveat that, as you know, we're going to conduct this investigation, and you know, you've got to participate in that investigation fully, and then we'll make a determination later, and that can change as we get more information. Conduct an internal investigation. Certainly, I think if you're bringing them back in, and the conduct is something that should be of concern because of the position they're in, then you can definitely conduct an internal investigation. Or you could just say, you know what, we're going to suspend you. We're going to conduct this investigation, but we're going to suspend you with or without pay, depending on what your policies are, and then we'll get back to you. And then, of course, you can terminate them on the spot, especially if they had, you know, make some admission to you of that they really engaged in the conduct. And sometimes they'll make an admission to you. They'll say, well, you know, they charged me with distributing a controlled substance, but really I didn't have that much. You know, it was just marijuana, and I just had, you know, it was just purely recreational use. I didn't have enough to be, it's not like I'm a drug dealer or anything. Well, they just admitted to you that they've broken the drug laws and probably your own drug abuse policy. And so that's enough to take action on. They just told you that they had, you know, they were in possession of a controlled substance for personal use. And even though they're saying, it's not what I was really charged with, and what I was charged with was a lot worse, and my lawyer says, well, plea it down. Well, that's fine, but they just admitted illegal activity, and if it's in violation of your company policy, you need to consider that, and maybe that's where you go ahead and terminate somebody. Whatever they tell you, you want to verify. Again, if all your employees and applicants were honest, I would be out of work. And you know, your applicants often will tell you one thing, and it turns out to be another. The same is for the employees. They may know that, well, I know I'm going to have to miss work for court dates, I'm going to have to do this stuff, and they may even find out that there's a case against me, so I'm going to tell them this one little piece of it, or I'm going to tell them something that's really doesn't make me sound so bad. So verify everything that they tell you. And now let's talk about the investigation. You're going to need to investigate this information and find out what really happened as best you can find out. And so the first thing you're going to encounter is this person's defense attorney is probably going to contact you and tell you, don't worry about it. We're taking care of this. We're moving forward with a defense of these charges against your employee. don't you worry your pretty little head about it. Well, you know, you've got to worry your pretty little head about it. And so if they intervene, you got to remember they're paid to represent and claim this person's innocence. And so you don't want to, in my estimation, you don't want to, you know, cooperate with the defense attorney to the extent that you're accepting whatever they say. You're not a member of the defense team for this person. And I would suggest if you're going to require law enforcement to get a subpoena for any company information, including, you know, maybe times that the person clocked in and clocked out and you know, their general whereabouts. If you get GPS on your company vehicles, that's something that law enforcement sometimes will ask for, and it's likely that the employee's attorney may want to see it too. So I would, if you're going to require law enforcement to get a subpoena, I would require the defense attorney to get a subpoena as well. You own that information, not the employee, and so I would make sure that you treat the prosecution the same as the defense in all of this. You should also have in your policies, in your employee handbook and in your policies, ought to have something that says it's every employee's responsibility to cooperate fully with a legal investigation into the conduct and behavior of employees. And, you know, failure to cooperate with an investigation and to participate fully is grounds for termination. So you got to follow that policy and remind everybody that you're talking to that this is the company's policy and that they're expected to cooperate with the investigation. So when you're investigating, what you want to look for are, first of all, are there other employees involved? So it's just one employee and he's convicted of, let's say, trying to sell stolen merchandise. So you see that, and turns out, as you know, that the same pawn shop where he was caught trying to sell this information, he's also sold a whole bunch of Waterford crystal, and you happen to be a bonded warehouse that's full of Waterford crystal. There's a red flag, and it was just one employee or other employees involved in doing this. So you know, this may be something beyond just the one employee who you know got arrested. There may be other employees involved. Maybe also just other employees who are witnesses, because especially the kind of things that happen at bars at night after work, and somebody gets into a fight. If there were other employees there, I would go capture their statements as to what they witnessed and what happened. Also watch for any kind of impact on the company or exposure for the company or customers. What is this going to mean if it's out there in the media? But also, you know, in some cases, especially white-collar cases, an employee might have committed, you know, been charged with committing some sort of illegal act on behalf of the company. You know, you think about robbery cases or things like that. You know, the Foreign Corrupt Practices Act on the federal level may kick in if you're, you know, paying bribes to foreign officials, for instance, to win a company contract. So just be looking for how what the blowback may be on the company or customers, and it may blow into a bigger investigation. You may even have to bring your an outside investigator or your legal counsel in to conduct that investigation if it's something of a bigger, larger extent. You always want to get copies of the relevant documents, the charging documents, the police reports, things like that. And I would say have the applicant or the employee bring them to you and bring you certified copies of those so you can look at them. Your background screening company can get some of those for you, but I would just say have it's faster to have the employee bring them to you, but you want them to be certified copies, original copies that are stamped by the clerk, so that you know they haven't been tampered with. And then you also need to know if there are any kinds of restrictions that are placed on this employee. For instance, you know, his DWI is case may not be tried for 18 months or 2 years, but maybe they put an interlock, a thing that he has to breathe into in order for him to get a temporary driver's license that allows him to drive, even though he's got this pending cases and his license is suspended, but he's got an occupational driver's license where he can drive to and from work and things like that. And so anything like that you may see, or an ankle bracelet, maybe in some environments an ankle bracelet isn't uncommon or it wouldn't be of concern to you, but in other environments you may not want somebody at your high-end retail store wearing an ankle bracelet as they're dealing with the public, things like that. And you also need to figure out, are they available for work? Are they going to be on an ongoing basis available for us to expect to be able to work? If they're not, if the job requires working weekends regularly, but they say, well, I've got to serve weekend jail, and on Friday through Sunday, and serve my 30 days, 3 days at a time. Well, that makes the person not available for work, and you've got to make a decision about that. Whether you're going to make accommodation for that or not. Now, here's the real thing, and I mentioned it before, and I want to keep driving it home. You do not have the standard as an employer of guilty beyond a reasonable doubt, okay? And even the EEOC has said this. So if the EEOC says it, I feel really confident doing it, because I disagree with a lot of what they say in the area of employers' use of criminal history. But even the EEOC says that if it's reasonable for you to believe as the employer that the person engaged in the underlying conduct, then you can make an employment decision based on it. And that certainly would apply to an arrest or something like that. So does it make sense? Do you believe that based on what you've received that the person engaged in that conduct? And certainly if they admitted it to you, that would do it. But perhaps, let's say somebody was charged with domestic violence. And so they were arrested, and you go get copies of the police report. And you see that Friday night, his spouse called the police. And then the police report, it says that the police showed up. She was crying and had a bloody lip. He was yelling and screaming and throwing things, and the police carried him away. Now, is it reasonable, based on that police report, is it reasonable for you to believe he engaged in that conduct? I would say yes. Is he necessarily guilty under the law? No, not yet. But that's not your standard. Your standard is it reasonable to believe that the person did that? And I would argue that you never care about that. Conviction is not the issue. And I have a hard time convincing some folks who are much more employee rights oriented than I am that this is true. But the case is, the fact of the matter is you're not making an employment decision because someone was convicted. You're making the employment decision because the activity that underlies the conviction makes them unfit for that position. And so they could, and we've already talked about how they can not be convicted and still have admitted or be responsible for the offense. I mean, I'm on deferred adjudication all the time, okay, for traffic tickets. And so it's like my local cop knows if I park here, Coffey will drive by and be at least 7 miles above the speed limit. I'm going to give him a ticket. And then for whatever reason, he leaves me alone while I'm on that 6 months of probation that they give me when I go down and pay the fine and say, I don't want this on my insurance, on my driving record. And so they say, you take deferred adjudication and just don't get another ticket in the next 6 months and you got no problem. But then 6 months and 1 day, he's waiting for me, it seems like. So that's deferred. And I was definitely speeding. And so that's how that works. And so I would say, yes, it's perfectly reasonable for you to believe I was speeding, but at the same time, I wasn't convicted. So as an employer, you care about the underlying conduct. Ask me questions about that if you want to, and especially if you want to disagree with me. So let's review that conduct. First of all, let's look at your company's criminal history policy. Hopefully you've got a policy already for when you're hiring people that says, for this particular kind of job, these are the risks that are associated with the job, and these are the kind of criminal conduct that would be of concern for us to put somebody in that position. We've got a whole webinar, and just putting that together putting together a criminal relevance matrix, and so it's on our website. It's recorded. You can go look at it anytime you want. But hopefully you've got that policy. And I would say you apply basically that same logic and the same guideline to an employee who's arrested. And so, let's see what, if we believed it was reasonable that he engaged in that conduct, then would we hire him for this position now? And if the answer is no, and you believe it is reasonable for you to believe that he engaged in that conduct, then I would go ahead and say, you know what, he's not eligible for that position now either, because we believe he's engaged in that conduct. Let's look at the work environment that they work in. What's that going to mean to, if this conduct, how does it affect, their eligibility to work with that in that environment? Especially if it's, for instance, if they're in a healthcare role with some access to prescription medications, either in a pharmacy or patients' rooms, then and they've had some sort of drug offense, you're probably going to make a connection there that we're not going to take that risk of putting that person in that role. And what other risks are associated with the position as well? Do they work with vulnerable populations? Do they operate dangerous equipment? Do they have access to personally identifiable information or account information? And does this offense play into any of those kinds of concerns? And do they have any kind of occupational license, or is your company have some sort of state or federal regulation that would be of concern for somebody who engaged in this conduct? And I would argue the sooner that you've got those issues worked out and identified, the better off you are throughout this process. And then, do you have a collective bargaining agreement that applies to this employee? It may have specific things you have to do in the event that you need to take action based on off-duty conduct. So you want to make sure you review that. And then if you're a government employee and you've got civil service rules, there's probably specific things you have to do in that environment as well to make sure that your investigation and your decision-making are in compliance with those rules. And now we also probably look at the employee's past performance and their length of service. If this is an employee who's consistently in some sort of progressive discipline, or their performance has just never been as strong as their peers, and hopefully it's documented fairly and accurately by your supervisors along the way, then maybe this is an employee we just say, you know what, we're not going to make any accommodation here. That employee's skill set and what they've been costing us in employee relations issues is enough that we just don't need them here, and this is the final straw, and we're just going to terminate them. Or you may say, you know what, this guy's a computer programmer that is, it's really hard to find people with this particular skill set, and we're gonna hang out for a while because this offense is of concern, but it's not enough to eliminate them from the position. We're going to wait and find out what happens, and then we're going to put whatever extra controls we may need to have in place to make sure that this person can operate safely in our environment. And so it's perfectly fair if there's a business need to do it to make those kind of judgment calls. And because the truth is, all employees aren't equal, just like all your children are not equal. Okay. And I love all my kids, but I love them differently because, and there are different things that make me proud and all of that. And likewise, your employees. And you've got some employees who are really key employees. They bring a great skill set. They've got a long length of service, and you've got a lot higher level of loyalty to them. That's one thing. Another employee who's not performing well, has only been with you for a few months. There's no, there may be no business reason for you to go over and above just to take care of that employee in that situation. Look at what you've done in the past with a similarly situated employee and try to be consistent with that, but also looking at our current environment, our current situation, our current skill set needs. You may make a decision differently than you did last time, but at the very least, you want to know what you did in the past so that as you document what you're going to do now, you can acknowledge maybe the reasons that you're doing something differently. Is there any concern about a discrimination claim or retaliation claim? If the person has, on Friday afternoon, he filed a sexual harassment complaint against his supervisor, and then Friday night he got a DWI and he's a truck driver, and you take action, is this going to look like a retaliation claim? I'd say in that scenario, no. But let's say he got arrested on Monday morning for failure to show up for jury duty, and the marshal came to the office and picked him up for failure to show up for jury duty, and you fire the guy right after he's filed a sexual harassment claim against the supervisor, I would say that might look like retaliation. So you want to make sure the severity of the underlying conduct and its connection to the job is strong, maybe even stronger, if the guy may be able to file a retaliation claim against you later on. And then also, what is this going to do to the company's image? The fact is that as HR people, as managers, our job is to protect the company and to provide the company a legal and compliant and effective workforce, which means, and to do that, we take care of our people. We do good things for our people. But it also can mean that, you know, we've got to act in the best interest of the company, which may mean that, you know, we cannot, you know, the company needs to take a very specific set of actions in this case. If somebody's accused of sexual assault and they get arrested and cases filed against them, and your company is, you know, pretty prominent in the community, or you've got you know, heaven forbid you work with vulnerable populations or something like that, you may need to take action, even if it's not directly job related, just because of the company. And it makes more sense for the company to take an action right now, at least on an interim basis, in order to protect the company from PR damage or any potential litigation later, any kind of risk. So you do your investigation, and you've gathered all the information that you can get. And so now here are your questions. Are we going to allow the employee to work? If you're going to allow them to return to work, document what accommodations you may have to make. You know, in the case of a DWI, you may need to say, you know what, we can't let you drive a motor vehicle for us anymore. So I know you normally take you usually run down all the registered mail to the post office on every afternoon. We can't let you do that anymore. And so we want you to have some, we'll arrange for somebody else to do that. Things like those are the kind of accommodations. Now, again, I use the word accommodation nervously because I don't want to suggest you've got any responsibility to do that, any legal responsibility. But it may make sense for you to do that, again, like I said, especially to preserve a long-standing employee relationship or a skill set that you need. If they are going to be allowed to return to work, they need to give you regular updates as to what's going on. You should always know when their next court date is and what happened at it. Again, you'll have them tell you that, but every now and then go back and verify it. Have your background screening company pull court documents, a copy of the court docket, things like that keep you up to date with what's going on. And whatever they told you, again, verify against court records on an ongoing basis. And at the resolution of the matter, you can decide about continued employment. And I tell them right up front that we'll review after we've gotten all the information after the case is concluded. We're going to make a decision about your continued employment. And it may be that you keep them employed, for a year and a half sometimes before a case concludes. But then after 18 months, they plead guilty and they get deferred adjudication. And often that's what happens. They will, admit responsibility for the offense in order to get deferred. Well, now they just told you, they just admitted that they engaged in this conduct, and the court won't let them do that. At least here in Texas, the court always goes back and repeats it back to the employee, so to the defendant, and when they will say, okay, so you're pleading guilty to this. You're admitting that you engaged in this conduct. Is that correct? And they will say, yes, that's correct. So now as an employer, you've got somebody who's admitted engaging in the illegal conduct, and if that conduct is at all related to the job, you've got to evaluate what your next response is. If you don't allow them to return to work, maybe you're going to allow them, to stay on your payroll with pay. But then, before you make that commitment, think about what that means. It can take 18 months, 2 years, or more for cases to move through the criminal court system. Do you really want to keep them on your payroll for that long? So you may want to have it really specific to the length of time that you're going to pay them. And again, they've got to give you regular updates as to what's going on, and you always want to verify what they told you. And then finally, if you decide to terminate them before the case has been adjudicated, are you going to allow them to reapply later? Are they going to be eligible for rehire? You've got to make those determinations. If you've terminated them because you believe it's reasonable for you to believe they engaged in that conduct, then I'd suggest that rehire is probably not an option. But if they bring you new information, or they find the one-armed man who killed their wife, and it's they're found actually innocent, then maybe you want to review that again and make them eligible. But generally, I'd say if you terminate them, you've terminated them, and until such time as you've got additional information that suggests that they didn't engage in that conduct for that you were concerned about, you probably don't want to bring them back. So let's go to the questions now. See, there's several. Good. Let me pull these up here. Okay, first one. I work for a small company. As part of our application process, should we be asking them to disclose convictions? Yes, depending on what state you live in. And send me an email offline and I can share some more information with you. And we've got a whole webinar on criminal history inquiries, when you should ask about criminal history. We recommend that employers ask on the employment application, except there are a handful of states and even some municipalities where you can't ask on the employment application. These states are what's called banning the box being the check box that an employee or an applicant might check off on the application to indicate they've got some sort of criminal history. I've got a whole webinar just on ban the box issues, and it's out there recorded on our website. But you want to follow state-by-state guidelines and to make sure that your question is legal, because there are some states where you can ask about everything. Like here in Texas, you can ask about everything. In other states, you can't. You can only ask about actual convictions or active cases. And so, in some states, you can ask the question on the application. The majority of states you can. But then in other states, you can only ask after the person's been selected for an interview. In some states, you can only ask at the interview or later. Some states, you can only ask after the interview. And then some states, you can ask after an offer has been made, a conditional offer of employment's been made. So all those issues, it can be really tricky for you. And so my advice would be to go ahead and figure out where you're at, and feel free to call me. We can talk about your specific situations. My phone number's there or shoot me an email, either one. But where you can, my advice is to get as much information as you legally can get about the applicant, because first of all, there's going to be some offenses that outright eliminate them from consideration, and then there's going to be other situations where you've got one guy who's got a whole bunch of minor, stupid convictions. Public intoxication 2 years ago, a theft by check last year, failure to appear on a traffic ticket, and he was, a whole bunch of just stupid, petty stuff. But when you're comparing this candidate with all the stupid stuff and another candidate who's got the same skill set and experience maybe, but he didn't have any of that noise in his background, who's going to be easier for you to manage, right? And so I think it's really important to include that to the extent that you legally can in your jurisdictions in evaluating employee A, employee B. It's just like, or applicant A and applicant B. It's just like if you were looking at former employees and you get former employers, and you get somebody who's been terminated twice from previous employment for cause, and that person, you may hire them, but if you've got a better candidate, an equal candidate who hasn't been terminated twice, that tells you something about candidate A and candidate B and how they stack up. So there's a lot to review there, and I've got several hours of webinars on all those issues. Feel free to look at them or send me an email. Thanks, Juliet. Keisha asks, understand there is no employer-employee privilege of disclosures. However, does that remain true if the employer reviews with their attorney? I would say talk to your attorney and ask them. My answer generally is probably no, because if the employer talks with the attorney, that conversation with the attorney will be privileged, but the conversation between the employee and the employer would not be privileged. So one thing you might consider doing is include in your policy that the employee makes the report to your legal counsel. That might work. I would say go talk to your legal counsel. I'm not a lawyer, and I'm especially not your lawyer. So, and you know, but that might be one way to do that. But this is, you know, again, I want to know why you really want to do that anyway. You know, why would you want to create that privilege? But it's something to think about. What happens if your jail calls HR and tells you that one of the employees is in jail? How do you handle that? Just like I mentioned earlier, you get some third party, whether it's law enforcement or some dude they met in the jail that weekend, or whatever it is, or the spouse even calls and tells you you treat it all the same. They've told, you've received this information from a third party, so and the person's not at work to talk to them about it, then follow your no call, no show policy first of all, and then after that, if you decide you're not going to terminate them based on no call, no show, let's do an investigation, and let's verify it independently that they're really in jail and things like that. And you could even do that yourself. You don't need your outside counsel or even your background screening company. All you can do is all you have to do is turn around and call the jail, give them the name and date of birth, and they'll tell you if he's in jail or not in most cases. And so that's how I would handle that, Robert. And I see it is Robert. I know Robert. Hey, Robert. Alma asked, can I show slide 16 again? I'm sorry. Sure, let's do that. Let me see here. Slide 16. I hope it's not just to look at my typos, but let's see what slide 16 says. It's a lot of clicks. Here we go. It's probably a better way to do this, but since I've got all these things popping up, there's slide 16. Oh, sorry. Notification policy. Oh, and by the way, Alma and everybody, we'll send out this a link to download the slides later, so you don't have to write all this down. Because you don't want to do all that. We will definitely email you out later on this afternoon or first thing tomorrow a link with the HRCI information, the SHRM recertification information, and a link to download the slides. What we ask is to get all of that great stuff absolutely free. We ask you to take a quick survey for us to tell us how I did today, because even though I own the company, my employees will get all over me if I don't get good reviews. So please do that. Do the survey, and then you'll get all that great information. And so the link to the survey will be in the email later. Okay, and Juliet asks, in regards to the notification policy, is it okay to include traffic citations if they are in the driving or transportation industry? Certainly it is. And some of our DOT clients have, DOT-covered clients have those kind of requirements in place, especially if you maintain a point system of any kind. Now, the thing to remember is they get a ticket this week, and they get 30 days to make their appearance or whatever, and they plead guilty and pay the fine. That still may not show up on their driving record, depending on the state, for weeks or months. And so if they, you can, if you keep a point system and they tell you, yeah, I'm pled guilty to speeding or whatever, or even and that's one thing with the point system. A lot of employers use point systems just based on the driving record. And so whatever's on driving record is what points you get. But really, in Texas and a lot of other states, deferred adjudications don't show up on a driving record. So you might be in a situation where you tell your employees that are drivers, you've got a responsibility to always tell us about any infractions you get. And because if they, again, deferred adjudication means they pled guilty or no contest. And so if you've got a point system, it may be fairer to all your employees to consider deferred adjudication as well. Laura, do I have any sample arrest and notification policies available for purchase? Well, what I would be doing there, Laura, is giving you the rope to hang yourself with. That's why we don't ever publish a sample policy, even on criminal history and things like that. We'll give you tools, and this slide deck that my great friend Julie Ross and I put together is probably a great start for your policies. But we don't write the policies for you. That's you know, I've just seen too many employers get in trouble because they've got a handbook that they copied from somebody or something like that, and it just wasn't really what they were doing. So, and I want you to consider your own environment and your own situation. Oops, let me go back here. So that's kind of a maybe. And certainly, Laura, you're one of my favorite clients, and anything I can do to help you, I would be glad to. Okay, let me see here. What about Open Records Act for public government? Does that negate the court order or subpoena requirement for the defense attorney? Kind of. If you've recorded documents, if you've got paper that you've got, then certainly the defense attorney can request those documents, unless there's an active criminal investigation going on related to the workplace. But you know, on the same side, if you get a subpoena to appear in court and testify about something, just from your own memory, Open Records Act would not govern you know, something that an employee told you or something unless you reduce that to writing. So that's the one issue. If you're a government employee, certainly Open Records Act in most states would, you know, the Public Information Act in Texas or Open Records in other states would govern, would allow you to get that information. So that's one thing you know, that's one way a defense attorney may get some of that information. Should the notification policy be a standalone policy, or should it be incorporated in the criminal convictions background investigation policy? You know, Cheryl, I don't have a real opinion on that. I think they'll probably refer, you know, it will probably refer back to your criminal history policy as far as how you determine what's relevant and all of that. And probably because I've got so many unique considerations in here, and I like policies that are easy to read and don't conflate different facts or different scenarios. I would probably have it as a separate policy, but there's no reason that it has to be one way or the other. But I'd probably make it a separate policy that just pointed to your policy as far as determining relevance of certain kinds of criminal behavior to the job. Is the webinar pre-approved for HRCI credit? It is, and SHRM credit. And like I said earlier, we will send out to everybody a link to take our survey and get that information. If an employee is arrested at work, would you advocate termination? Not just because they were arrested at work. I'd still want to know the details. For instance, like I said earlier, if they were arrested at work or taken into custody at least for failure to report to jury duty, I don't think I'd terminate somebody from that by that. I'd probably write them up and tell them, hey, take care of your business because we don't want your business coming into the workplace. That's just kind of silly. But I don't think I'd necessarily terminate them for it. So it would depend on the conduct. But in some environments, I mean, certainly, you know, if it has a really negative impact on the company, and if the offense is, you know, particularly concerning, you know, maybe I would. But I can't think of a situation where just because they came and arrested them at work, I would advocate termination just because of that. Because quite honestly, that's where they can find you, and it also is easier for law enforcement to do that. I mean, it happens a lot. That if they know where somebody works, they'll just go pick them up at work. You may get contacted. That's something else that maybe I should create a slide for. You may get contacted by law enforcement, and they may tell you, hey, we've got a warrant for this employee, and we'd like to serve it. It's perfectly okay for you to say, okay, here's what I'd like to do. I'd like you to use this entrance, and we will bring the employee down to you. And if law enforcement agrees to that, if it's not a something that's really, where they're afraid he's going to flee, then that's fine. Now, if they say, you know what, this is a really, this is a serious offense, and we're concerned that he may flee, and we want to come in, then I would probably accommodate them there as well. But you just got to look at the circumstances. But often, my clients who've had those kinds of issues, law enforcement's been really reasonable and really, generally helpful, and doing it in a way that doesn't disrupt the workplace too much, because that's, they're not looking, quite honestly, to in most cases, to make a big scene. And you might even pull the employee in and say, law enforcement just called me. They've been arrested, and they'd like you to meet them downstairs in the lobby, and in 15 minutes they'll be there. I'd like you to go down there and meet them. And you're the employer, and they're on company time. You tell them to go down there, they're going to go down there. But if it's a violent offense or anything like that, I would not necessarily advocate doing that. And no other questions? I got a couple I agrees, so whatever you agreed with, I appreciate that. And if there aren't any other questions, we'll end this webinar. I really appreciate everybody staying. Please take the survey. Even if you don't need the HRCI credit, please take the survey, because I really covet your feedback. We do this series of webinars for our clients and for our friends in the community, HR community, and I hope you find them valuable. So in the meantime, I hope you all have a great rest of your week. Hope your schedules are getting back to normal with school and everything else with your kiddos. And if I can ever be of service, please don't hesitate to give me a call. I always forget to actually try to sell us. We're a background screening company, and quite honestly, the level of attention and detail you've just gotten in this webinar is reflective of the way I've built this whole company over the last 16 years. We really take good care of our clients. We're a little bit more expensive than most of your quick and cheap options, but we'll really take care of you and be proud to do that. So if there's ever opportunity to help, please don't hesitate to give me a call. And otherwise, hope to talk to you soon. Bye-bye.